the restatement of trust talks about the duty to account. And this is pretty self-explanatory, but it says if you are a fiduciary, you got to keep records, you got to do everything properly, and you've got to account to the beneficiaries. So the accounting to the beneficiaries is where a lot of this comes into play. So traditionally, when you get, next slide, Tony. Traditionally, when you get the when you get a big stack of papers from the from a trustee or a trust department, and they say, okay, this is our accounting, and traditionally you just kind of look through it, double check some of the math, do the attorney's fees seem reasonable, are there any unusual expenses that you need to talk about? There's usually never any review of assets held by the trustee, and then once it can go to the court, the trustee's conduct is approved. What makes this interesting from a malpractice standpoint is that a trustee may not have to account to beneficiaries sometimes for 5, 10, 20 years when you have a trust that was set up, say, by a grandparent, and the trust is going to run until a grandchild reaches 21. There could be a lot of fishy things going on, and nobody knows about it until 10, 15 years later. And then there's the question is, when does the statute of limitations on all the malpractice run, and so forth. So that really gets up into some of the discussions that Tony has. And then this is the defining the fiduciary duty of professional advisors and the standard that they're supposed to be held to. So now I'm going to give you probably the most important thing I've talked about so far. And this is the code number that you need to write down and put in later in order to get your credit for this. And Tony's going to give one at the end. But the first code number is 74326. It's 74326. And now we're going to take it away, Tony. It's all yours.
Okay, thanks, Ron. Good morning, everyone. As Ron said, this is an update of something we did a couple of years ago. We never got through the whole presentation the first time, and we rushed through some things and probably covered some things we didn't have to. So we've tried to make it a little bit more presentable and a little more current, too. There's been some recent developments, and we'll talk about those. So let's see. I got a problem with the slideshow here. Hold on a minute. Bear with me just 1 minute. Well, let's see. I'm going to take it off and then put it on again. We're getting used to these Zoominars, but we haven't got them down pat yet. Let's try again. Okay. So I start where Ron was part of the middle of Ron's discussion, and as he said, there are plenty of fiduciary standards out there, many of them statutory, some of them are not. This prudent investor standard that was up on Ron's screen for a minute is actually much longer than this slide would suggest. It's probably a page and a half long, and it indicates various things that a prudent investor, trustee, or fiduciary must do. But what I've highlighted here is the duty to diversify assets. First of all, it's interesting to know who this applies to. This applies specifically to statutory fiduciaries, and that would be anybody who's not only a trustee but an executor of an estate. It doesn't specifically apply to an administrator of an estate, but probably the cases that have developed would apply to that kind of a person. And it probably would apply pretty much to anyone who's in a fiduciary capacity with respect to investment responsibilities, a fiduciary of an employee pension account, or an investor who's been hired to make investment decisions for his or her client. So the standard is that you must diversify unless there's a good reason not to. It didn't used to be presumptively required, but it is presumptively required now. Now, that doesn't mean a portfolio has to be diversified. Sometimes a portfolio is not supposed to be diversified. There are trusts that have been set up in the past. For example, there's one in a litigated case called Dumont, in which the grandfather who set up the trust had a lot of Kodak stock, and he put in his trust instrument specifically telling the trustee that the stock was not to be sold just for diversification purposes, but only if there was some other compelling reason. Sometimes it's not in the interest of the beneficiaries to diversify the portfolio, at least immediately. For example, if there's a large capital gains tax that's going to be recognized, you need to take that into consideration. Again, related to that is sometimes it's not, if you inherit a large concentration of some stock, it's not necessary to dump it all at once necessarily. That might be the right thing to do, but it may not be the right thing to do. And all of the law requires there is that the fiduciary develop a plan and document that plan. The obligation is to deal with it, not to ignore it. The other one thing, I should go back to this a minute. This talks about a duty to diversify, and diversification, we'll talk about in a little bit, technically means not keeping all your assets in one category. And you could diversify by having assets in different asset categories, but you could still have a problem if you have a heavy concentration of one particular, for example, security in securities portfolio. So if you're looking at a portfolio of bonds, stocks, and cash, that's a diversified portfolio in some sense. But if you've got a heavy concentration of a particular stock, you may still have an issue here. This all started out, as Ron suggested, with a case called the Matter of Janes back in 1997, and in that case, it was a case against Chase Bank, but in that case Chase was not a trustee; they were an executor, as any of you or I could be, and our friends will, or our colleagues or our clients will, could name us as executor. That the bank was an executor in a will, and when the decedent died, his trust or his estate had a $2.5 million portfolio of stocks and bonds, and 1.8 million of it was Kodak stock that was inherited by the bank. So the bank made some immediate sales to deal with immediate cash needs of the estate, and then at that point had a portfolio 60% Kodak, trading at $131 a share. The bank inherited that. Oftentimes, an executor, the law contemplates that an estate will get wrapped up fairly quickly. So if an estate can get wrapped up in a year or so, it's less of a concern maybe that you immediately deal with any kind of concentrations. But in this case, the estate remained open for more than 7 years. And over that period of time, the Kodak stock price declined from $135 a share to $47 a share. The bank didn't move it in all that time, and didn't diversify it in all that time, relying on it as being a blue chip stock, and also being a stock that the decedent had deliberately accumulated for the benefit of his family. So they said, well, there was no reason for us to diversify it. The widow sued, and the court ended up ruling, based on expert testimony, that in fact the bank should have diversified that portfolio, that concentration, within 30 days of becoming executor, and should have reduced that down to 5% of the portfolio. That was based on expert testimony that said it was unduly dangerous to hold that kind of a concentration, and the bank ended up paying more than $4 million based on a formula that court developed. As I say, the arguments in that case were that it was a prudent investment because Kodak was a blue chip stock. It remained a highly regarded stock throughout the 7-year period, notwithstanding that it took some hits. But what the court said was, that's great, but there's two problems with that. First is just an inherent risk in putting most of your eggs in one basket. Never mind all your eggs, just most of your eggs. And it also overlooked the fact that diversification is desirable because there's more than one great stock and more than one great investment. So that's something you really have to consider as well. Now, on the other side of the coin, a more recent case, matter of Knox, this was another scenario in which a decedent died and left money in an estate, and then the estate poured into a trust. The trust held 40% Woolworth stock, which was more than that when the grantor died, but when it came into the trust, it goes down to 40%. In this case, the bank was not surcharged, and this was an appellate court in our part of the state, the Fourth Department. The court said, first of all, the first objection is the GAL is the guardian ad litem, who represented some of the kids, beneficiaries. The guardian ad litem had said, look, the bank trustee here failed to diversify. That's required by that Prudent Investor Act. They were objecting to overweight concentrations. But what the court here said was, wait a minute, the bank didn't violate the duty to diversify. The account was in fact diversified. It was diversified in investments, securities, cash, bonds, and the securities were spread over different industries. So the court said there was no failure to diversify in this situation. They also said the fact that the petitioner held an overweight percentage of a particular security was not shown to have been imprudent under the circumstances of the case. Now, Knox had a peculiar aspect to it, which I think was the main reason for the decision. In Knox, the trustee was specifically authorized, under this language I put in front of you, to advise with counsel and be fully protected in respect of any action taken in accordance with the opinion of counsel. Well, in that case, the bank never consulted their attorneys about any of this, but they did consult with one of the decedents, I think it was a child or a grandchild, who was in the investment business. And that relative said, no, we like the Woolworth stock, keep it. Whether we think it's a good reason to keep it, here's why I think we should keep it. I don't remember what the reasons were that he gave, but he gave the reasons, and the bank said, okay, we're going to rely on that. And the court said, you know what? There's nothing in the trust agreement that says counsel means a lawyer. The bank took counsel from somebody who was a family member who had some expertise, and they were protected. But I got to tell you, that's in my experience at least, a pretty rare kind of a provision in a trust agreement. And I think if it weren't for that provision, this case might have turned out differently. A case that did turn out differently in 2013 was a case called Matter of Hunter. This was another situation in which a bank was a trustee, and the court held that the trustee violated the Prudent Investor Act. Now, that's what we just looked at. It said you have to diversify. By holding a 75 to 80% concentration of Kodak stock in a trust for more than 20 years. Now, the trustee did eventually reduce the stock holding down to 22% of the Kodak. But for a lot of years, it held on to the Kodak in a pretty high concentration, anywhere. It was 80% down to 60% before it really started getting sold off. And here's why the court faulted the bank in that case. It said, first of all, courts recognize that you don't necessarily have to diversify a portfolio or reduce a concentration if there's a good reason not to. But in this case, the court found that the trustee never even formulated a plan for the trust that included diversification of that concentration. In other words, it failed to come to grips with the fact that it had a concentration, that it was risky, and that it needed to deal with it. That was the main holding of that case. If there had been better evidence that the trustee had confronted that concentration, acknowledged the risk associated with it, and developed a plan to deal with it one way or another, it would have been a different outcome. The other thing that hurt in this case, the bank trustee, was that the trustee had its internal policies and it violated its own internal policies. This is pretty customary in trust departments, where there will be a policy that says, if any particular holding exceeds 10% or 20%, we're going to give special attention to it, and we're going to reduce it unless there's reason not to. In this case, the bank failed to do that too. So the bank got surcharged. Now, this was an interesting case because, in fact, over the more than 20 years that this trust was in place, the Kodak stock actually ended up making more money or being more valuable at the end than it had been at the beginning. On the graph I'm showing you, the red line is the value of the Eastman Kodak stock over that period of time of 1972 to 1987. And the green line above it is what the S&P 500 did during that same period of time. As you can see, the Kodak didn't plummet over that long period. I mean, it actually was a little higher per share at the end than it was in the beginning. But you can also see that over the long period of time, Kodak substantially underperformed the market on average. And as a result of that, the court found that the trust had been damaged by holding on to that stock in concentration as the trustee did. And again, that case resulted in another, I think, a $5 million hit against the bank for damage that the court found that the trust suffered because of the holding on to this concentration. Now, another case that never went to court, but I'm familiar with, involved a holding of Gannett stock. A grandfather had set up a trust, and he had been one of the founders of Gannett, and he had a lot of Gannett stock in his portfolio. This is just like in James, just like in Hunter. The family had a sort of love of the company based on Grandpa's relationship with it. It paid high dividends for many years. It had a very low tax basis, so that implicated questions about capital gains taxes if it were sold off. And the bank held it for a long time, only sporadic sales. But in 1994, it actually started to reduce the holdings deliberately, just in recognition of the fact that there was a problem with the concentration. They took it down from 60% to 40%. But then they stopped. They stopped diversifying or divesting, and so they got to a point where the concentration was at 40%. They stopped selling off, and it declined. But the stock value declined, and just because of the mere decline in the price of the stock, the concentration dropped from 40% of the portfolio to 20% of the portfolio. Same number of shares, just the value relative to the rest of the portfolio had declined that much. In this case, the bank trustee had maintained a common trust fund, as many do for smaller trusts, and this one wasn't part of that. But in looking at that common trust, we learned that the bank itself had divested its commons fund of Gannett altogether by 2007, yet it continued to hold a substantial amount of Gannett stock in this particular trust. Let's see here, I'm freezing up again. Here's what Gannett did over the period of time that was an issue. Again, the S&P 500 is at the blue line at the top. The orange line at the bottom is the Gannett share prices over this period of time from 2004 to 2012. You can all see that dip in the middle, which was the correction of 2008. Most of us can probably still remember. And as you can see, at the very beginning of this time period, the Gannett actually outperformed the S&P 500 in the very early going. And as I said before, it was paying a nice dividend at the same time. But it didn't take long for it to depart substantially from what the rest of the market was doing. And by 2000, looks like by maybe summer of 2007, it was substantially below. It had performed substantially worse than the market generally. But at that point, it became in step with the market. You can see the Gannett was declining, but so was the market generally. And when everything bottomed out in 2008, they both bottomed out together. One of the problems was that the market, the S&P 500, generally recovered at the rate you can see there in blue. Gannett never did recover at that same rate. So the problem, there were two problems here with this concentration. First of all, from 2004 to 2006, when the selling plan had been suspended, Gannett took a dive relative to the rest of the market, and that hurt the trust a lot. It reduced the value of the portfolio by, I can't remember the dollars, but from 40% to 20% was just this one investment alone. So that was a problem. There was damage under the trust right there. The other thing that hurt here, and this is particularly pertinent to the circumstance we're in now, coming out of the correction, Gannett just did not do didn't come out of it as well as the market did generally. You know, if Gannett had been a winner after that particular decline, maybe the bank never would have been sued, but it wasn't. They guessed wrong. They held on to it. They guessed wrong. It came out of it a loser, and so the trust suffered additional damage because of that. So that one case there was no case there that went to court, but there was a substantial settlement in that case. So the question is, how do you detect and evaluate concentrations and how they were handled if someone comes to you with an accounting and says, okay, here's an accounting I've just been asked to sign off on. What do I do? Well, first of all, many of you are familiar with this, but the standard form of accounting basically tends to be a fairly thick document. It requires the fiduciary to identify whatever principal it received, any realized increases or decreases in the principal from selling of assets, any expenses it paid from the assets, any claims that are outstanding against the assets, any distributions that were made from those assets, and any new investments that were made from any sales of assets, and then the principal remaining on hand. So the principal received, principal remaining on hand, they're often very different. In any well-managed estate, they're always different. The selection of assets in the portfolio when it was first received by the trustee is seldom the same as the portfolio when it's at the end of the trust. And then there's typically a similar reporting required for the income side. Sometimes it's easy to see that there was a problem. The matter of Jane's case I talked about from 1997, in which Kodak was the principal piece of the estate. Here's what the accounting showed. So Schedule A, the principal received. If you looked at that, you would have seen that the assets that the executor received included about 13,000 shares of Kodak stock with a value of $1.7 million. And if you did a little math, you'd see, well, back then it was 70% of the equities that the executor received, and it was 50% of the entire estate. So it's easy to see that executor inherited or assumed responsibility for a portfolio with a large concentration of one issue. If you go to the end of the trust, the executor's trust account period, Schedule O showed what was left at the end. At the end, there were still 11,000 shares of Kodak stock, and the market value had dropped to $530,000 or $46 a share. So that was a pretty easy one to detect that there had been a problem. If you look at what was received, you saw a big concentration of Kodak stock. If you went through the middle of the accounting, you'd see some distributions of stock, some sales of stock, but not a lot. At the end, you'd see the estate's still substantially Kodak stock, but that Kodak stock has plummeted in value and taken the value of the estate with it. So in that case, that accounting, it was fairly easy to see what the effect of the impact of the concentration had been. Now, one thing I want to say here, we're talking about cases that involve bank trustees and bank executors, but these rules are applied to any executor. There was a case out of Albany County just last year in which an attorney who was appointed an executor was surcharged over $2 million personally because he took over an estate with 85% General Electric stock and didn't do anything with it for 7 years, and that stock declined substantially in value. And that attorney, although not a professional investor by any means, got whacked for over $2 million for failing to diversify that money. Now, a second example, this is a more difficult example. This is that Hunter case we talked about. As I mentioned before, well, there were a couple difficulties with this one. In the estate cases, if you're dealing with a single accounting from an estate, you know what the value was when assets were received. You know what they were at the end of the period of administration, and you got a complete picture. In many cases, though, and particularly with trusts that are long-lived, there will be various intermediate accountings that will be taken by the trustee. That maybe after a beneficiary dies or after some person dies, there's typically an intermediate account, even though the trust itself hasn't ended. And intermediate accounts can create difficulties in interpreting later accountings because The intermediate, the first accounting uses something called, every accounting uses something called an inventory value for the assets they receive. And oftentimes, inventory value is not the same as market value when you're talking about a successive accounting, a second or a third intermediate account, or a second or third account after the first one. So the value of a asset that's reported at the beginning isn't always market value. The second problem in Hunter that was the challenge was, in this case, the trust that we were looking at had actually received its assets on 5 different dates over a period of 4 years. So there were different values of this stock as it came into the trust. To make matters more difficult, so first of all, it was apparent that it did become apparent once we translated the values of the stock into market values at the day that they were received by the trust. We could see, okay, we see the market values, we see it's a concentration. But there were also a lot of gains shown over the years as Kodak stock was sold, particularly in the later years. This was that case I mentioned before, in which not much was done in the beginning, but an aggressive diversification program was undertaken later. So there were multiple gains shown in the Kodak stock, and there were 2 Kodak stocks splits. So it was difficult to determine whether there was an issue here. As I said before, the principal, the Kodak concentration got reduced down to 22% of the stock portfolio by the end, and the total dollars realized on the Kodak stock by the end of the accounting period was more than the value of the stock when it was first received. Nevertheless, the trustee was surcharged over $5 million for failing to reduce that concentration during the accounting period. And here's why. This is, again, we looked at this before. Despite the fact that there was more Kodak value at the end than at the beginning, the Kodak stock had lost a lot of value relative to the market generally during the period of the trust. So again, the S&P 500 is the top line, the Kodak is the bottom line. All that value was lost, and what made matters more difficult for the bank was, well, you'll see here at the end of this trust period, at the end of this graph here is, it's hard to read it, but it's August 1987. There was a major correction. I think it was October of 87. No one will remember where values declined substantially. And in April of 87, the bank trustee kind of woke up and he said, we're holding an awful lot of concentration of Kodak here. We really ought to diversify it. And they sold a relatively small amount of it, but that was all they did. And the court said, look, you knew then you had a problem. You didn't deal with it. You should have dealt with it. You could have sold all that stock down to 5% then, and you didn't. So we're gonna basically punish you for it by making you pay back to the trust the $5 million in value it lost. So how do you actually figure out what you're looking at when you've got an accounting from an estate or from a trust that involves investment assets? Besides the accounting itself, one of the first things you need to look at is the trust agreement or the will that creates the estate. As I said, there will be language in there that will guide the trustee. There may be language in there that directed the trustee to hold on to that particular asset, or directed the trustee to hold it unless there's a compelling reason not to do so. If you're the trustee, you've got to follow that guidance. If you're a beneficiary who thinks you have a grievance, you're going to be bound by that guidance. So that's important guidance to identify. You need to look at prior accountings. Again, one of the reasons is you'll need that in order to help figure out the market value versus the inventory value. And it's also helpful to look and see what the prior history of the portfolio was. In that Knox case I talked about earlier, involving the Woolworth stock, one of the important factors in favor of the bank was during the trust period in issue, they had a concentration of 40% Woolworth. But if you looked at the immediately previous period, the bank had fairly aggressively reduced what was almost 100% concentration of Woolworth down to 40%. So it was clear to the court that the bank had been attentive. The trustee had been attentive. It wasn't ignoring this concentration, and so it was important data for the trustee to bring to bear in its own defense in that case. One of the most important things I find is monthly account statements, because the monthly account statements will do two things. First, they'll give you the actual market values of the assets in the portfolio, so you don't get to get confused about inventory values. And with actual market values of the portfolio, you can figure out what percentage a particular asset is of the portfolio. But the other thing it lets you do is it lets you trace the history of the portfolio over the period that you're looking at, the period of the estate or the period of the trust. It may be that there's an asset that was not a concentration when it was first received, but became a concentration later. So it's useful to, really almost imperative, if you're looking carefully at an accounting and dealing with a large portfolio, that you need to look at the monthly statements over a period of time and evaluate the portfolio over a period of time. I wrote here bank investment policy, but I really mean trustee investment policies. Individuals like me who might be asked to be an executive, I don't have a trust policy or investment policy, but most professional trustees do, and you got to look at those. I say here bank exception reports. In my experience, most bank trustees, trust departments, do have a periodic review process, and they will generate, with the help of computers, they can identify assets in a portfolio that have exceeded their policies. And an exception report will also often identify for the trust manager assets, particular holdings that have exceeded or triggered one of the bank's policy exceptions. So those are important reports to look at. And they're important reports, obviously, for the trustee to take consideration of. Many times it'll be a trust review committee meeting, and those exception reports will be discussed, and a notation will be made in the file that here's what we're going to do about it. And those kinds of records are very valuable to a trustee. But unfortunately, it's also the case sometimes the exception report will be there in the file. The minutes of the trustee review meeting will be produced, and nothing is said about how that exception report was dealt with, or how a particular exception was going to be dealt with, or if it was going to be dealt with at all. So those are important documents to look at if you're reviewing an account on behalf of a beneficiary. And by the same token, the investment committee will have minutes that are important to look at. Again, what's important, whether you're the trustee or whether you're a beneficiary who feels aggrieved, what the courts are looking for is evidence of attentiveness to the portfolio and evidence of attentiveness to the asset that may be in concentration. The court wants to know that the trustee is dealing with it prudently, has a plan for it, and is dealing with it. And if they're doing that, they're probably going to be exonerated. And if they're not doing that, they're at risk of being surcharged. So here's a simple bank investment policy that from one of the cases I was involved in. It's not that different than anything else I've seen. In this case, it said the bank recognizes the value of diversification, and furthermore had a policy that the market value of the securities of one issuer will not exceed 10% of market value, subject to a compelling account considerations. And this is a pretty typical kind of a investment policy provision. And again, the lesson is if you've got something that's exceeding this policy, and you think you got a compelling account consideration for maintaining it, you should document it if you're the trustee. If you haven't documented it, then a beneficiary is going to take advantage of that, perhaps. Something else that's useful is guidance lists. The example I've given you here shows for the case that involved the Gannett stock. One of the reasons, the greatest reasons the bank gave for holding on to that stock so long is it was always paying a very healthy dividend. And so, and income generation was an important component of that trust to the family. All the beneficiaries were looking to get income from this trust, and they relied on it. But the bank's own investment guidance list showed that almost a third of their stocks on that list were paying dividends higher than what Gannett was paying. So Gannett wasn't the only high-paying dividend stock around. You could have divested out of it and maintained high dividends. In the Woolworth case that we talked about, where the bank was exonerated. I say we're exonerated. They weren't entirely exonerated. In that case, what happened was by a certain year, I don't remember, it may have been in the 90s, by some year, the bank's investment guidance list had dropped Woolworth from its list. And at one point it was a buy, then it became a hold, then it was dropped from the list altogether. And what the court said there was, look, as of that point in time, once the bank dropped Gannett from its list of advisable investments, at that point the bank should have done something to diversify that concentration, and it didn't. So to that extent, the bank trustee was held responsible. Another thing that courts will look at is these first equity common trust funds that a lot of trust companies maintain. Again, a lot of companies will maintain common trust funds where they'll manage assets of smaller trusts together that really don't justify maybe economically individual management. And so again, in this Gannett case, we looked at the first equity common trust fund of the bank, and on the date April 30th, 2004, it included 39 separate stock issues, including Gannett. But in that case, no single equity was more than 4% of the fund value. And in that case, the Gannett was only 2% of the fund value. So, we look at that and we compared that to what the bank was doing with the actual trust. And obviously it was much different. At that point, they were holding 60%, or maybe it was 40% Gannett. It was just a stark disconnect when you compared the two. In this case, by 2007, the bank had completely divested its common trust fund of Gannett. But again, they continued to hold it in the trust. So again, that's the kind of information that I look for anyway when I'm looking at one of these accounts. So some special cases. We already talked about the fact that an investment could become concentrated over time. You may inherit a trustee or executor may inherit a diversified portfolio without any overweighted positions, but over time, because of declines in the market or increases in value, frankly, you get lucky with a couple of stocks, and all of a sudden the Microsoft stock in the portfolio is now a third of the portfolio. That's wonderful, but you're a trustee, and you can't speculate that it's going to go higher. You've got to be prudent, and so if that happens, you need to look hard about divesting that concentration, or you maybe have trouble with it later. The others I've labeled here are sort of typical things that any investment advisor would be familiar with. Concentrating in a particular industry can be a problem, even though it's not a single company. But if you're concentrating in a particular industry, that can be a problem. Particular investment vehicle. One of the interesting questions that I don't have an answer for is, what about cash? A lot of times an estate will have just cash, or maybe you liquidate especially a more modest estate. Maybe you liquidate what you find, you sell the house, you sell the jewelry, you have some other things, and you got $200,000 in a money market account. Are you safe holding on to that for 7 years? It's probably not prudent to do that, but the way the courts evaluate damage to an estate, you probably would be all right. The court would probably say there was no damage done to that estate. But this is an evolving area of law, and prudence has to reign. So if you're a professional advisor, bring your expertise to bear. If you're not, and you're holding on to assets for a long time, get some advice. Family businesses, Ron mentioned these. Sometimes an estate or a trust consists largely of a family business. It's not necessarily, there's still an obligation to consider diversifying, and you need to document if you're not going to, but there's very good reasons. If the grantor, if the family business is profitable, if the family business is difficult to market and sell, those are all good reasons why you could hold on to those assets in the trust or the estate, but you need to document it somewhere. Employee stock ownership plans, and these by definition are to hold substantially or primarily the assets of the particular employer company. Is there a duty to diversify? No. The stock agreement itself, the trust agreement itself, tells you don't have to. But you still have to be prudent about it. If you know that the company's stock is overvalued, then you may have an obligation to stop putting money into that investment. Insurance trusts, this is a single asset by definition. No duty to diversify here, but there's still a duty of prudence. Even though the trustee may not have an obligation to pay premiums if there's not money in the trust to do it, and may be authorized to take policy loans to do it, you got to watch carefully the loan balances. If you don't want to get the insurance trust in a situation where the loan gets so high that there's a danger of lapsing the policy and all of a sudden creating a huge tax problem for somebody. So you have to be prudent. You have to document. That's all I have for presentation at this point. I'll turn it back to Lynn.